petitioner Andrew Larson came, submitted a petition titled in reinforcement of Senate Rule 4, Section BDI.
And it's the document titled November 18th case submission.
Yes. You guys all have that?
Yes.
All right, so for jurisdiction for that case, I do see jurisdiction through Article 5, Section 3.2. In terms of being decided before, considering the rules and procedures of the Senate were amended this spring, I don't believe it has ever been amended this way before. So I don't believe there's existing precedent for this case.
Yeah, we had a conversation last year about public comment for senators, but I agree it was a different Senate bill or different regulation, so I agree that it's not included.
Okay. I do see where petitioner is coming from. I do see that not being able to speak at a regularly scheduled time and place is violate the Constitution of the University of Florida. However, I will say that there is also time to speak in the announcement section, but I do see how this does directly violate the section. So, you guys have any input on this?
I agree with Stephanie's point upon reviewing it. That's kind of what I was thinking when I was going through the argument.
Yeah, I believe we dismissed a case last year. I don't think it's in your order, but I think it was dismissed at a preliminary hearing. But I think that it would be good to go forward to an official hearing or oral argument. Yeah, to hear what petition wants to say.
Because I also understand what you're saying, and that there is a little bit of time for them to speak, but I think what petitioner has brought up is important. So I think moving forward to hearing would be beneficial.
Okay. All right, so we'll take the vote on whether to dismiss or proceed to oral argument. If you would like to hear the case, then raise your hand. Do so now.
Do we have to wait, since we're not doing video recording, do we have to also say?
That's what we have to do.
Yeah. So I.
I, Griffin, both of you saying, go better for the recording.
All right, you guys can record.
Oh, you can. We're recording.
Okay, cool. The next position is in reconsideration of in reinterpretation of Student Body Statute 322.51's constitutionality under Article 1, Section 4. It's from petitioners Jordan Hall and Andrew Larson. First, to address jurisdiction, it does appear that jurisdiction is present for us to hear the case under Article 5, Section 3.2. In terms of precedent for this case, it seems the petitioner is asking us to do something based on our previously issued opinion. What are our thoughts on this case?
Yeah, I think first looking at the first request for relief, which is recusal, I think that recusal is not appropriate. I think that looking in the Student Body Statute describing the potential grounds for recusal, I think none of those are met. But I understand the petitioner's concerns, but I think that what this is just a lack of clarification from the original ruling on November 16th on in reinterpretation. And I can understand the confusion. I think it's important that it's made known that after Justice Birkin issued the opinion, she updated it to Jerome to say that the petition is denied rather than dismissed, because it was not dismissed for lack of jurisdiction. So I just wanted to, clarify that this was interpreted according to Section 3B1 and, determining us putting forth an interpretation of what the Student Body Statute 322.51 is saying, and then for the question of constitutionality separately under the anti-discrimination clause, we found it was not unconstitutional. But I can understand the lack of clarification from the opinion as written, and so I think it could be helpful to maybe talk through it again, talk through it some more, and go forward to a real hearing to discuss it further. I don't know, I just don't want to have any lack of clarification from our end. So.
I agree with that, and especially as the one who drafted the original thing, I think going forward to a hearing, so again, with transparency, so it's everyone is clear what we were trying, or what I was trying to say, would be best.
Yeah, I understand the importance the student body statute because it deals with
Yeah.
the apportionment for elections, so I understand the need to have clarification on that, so I think issuing an interpretation coming after an oral argument would probably hold more weight and would be better for the student body as well.
No, I agree.
And to issue a new opinion, we would have to proceed to oral argument, so.
Yeah, I think we should. Yeah, fine.
Alright, take it to a vote, we'll say aye for here, this is for oral argument, we'll say aye.
Yeah. Like, we're gonna use it, or can I,
Yeah.
Those were,
right? Who's saying the name is good?
Alright, the next petition we're gonna hear is in re fall 2026 election unfairness, brought by petitioner Tyler Sklar. In this case, petitioners are requesting a student body, or not student body, but a group, aka the elections commission, to do something for jurisdiction under 3D or 3D2 of the Constitution, of Article 5. In terms of precedent, according to Henry Lewis and the elections conflict, there is jurisdiction for us to hear the case. Standing is satisfied by alleging a claim under Section 2A, Article 1. With other precedent that has regarded an election map, the map we currently have is different from previous precedent. What are y'all's thoughts on the case?
well, just starting with standing and looking at the injury. I mean, like, it's a little bit difficult because the injury is kind of as a whole, fairness as a whole, it's a little bit abstract. And looking at the case they said in their election conflict, on the October 3rd, 2022 case, it's in the third reporter I was looking at earlier, and I chatted about earlier the footnote, that says that decision is not an endorsement of the Lewis standing decision, and later Supreme Court decisions may find it appropriate to review whether an allegation of an infringement upon students' right to vote alone is truly a concrete injury capable of satisfying the standing requirement. So I mean, if you'll take my coach and see, like, standing, we can always find standing and then realize that there was no standing, so standing can always be lost on the jurisdiction. So we could, we could talk about it and hear the case and still later decide that there's not standing. So I don't know, I think the injury is a little bit iffy, but I would understand granting something this case.
I agree. One point that I was focusing on was the concrete injury argument, and I would like to see that go to our oral argument because we have had similar topics sent to the Supreme Court almost every election cycle. So I think it's important to distinguish and to clarify because petitioner's argument in this case over concrete injury, I would just like to see more and understand further where the lines are drawn. So that's one of my main opinions on this argument from petitioner.
I understand your point about it being a different election map. So I do obviously like the Henry Fall 2024 election map case. Petitioner was really trying to distinguish it because it feels incredibly similar of who's being denied, who's not getting their political will expressed. Well, the non-majority, the minority, which again, as we felt, is not a political opinion to be discriminated against. But I do see their point that this is not an Article 1, Section 4 discrimination claim. This is just fairness as a whole. Yeah.
I think one thing I do wanna make note of is we wanna make sure we're not just hearing it purely because it's a different map. Like that in itself doesn't require us to does anyone understand what I'm trying to articulate?
Yeah,
It's like just because it's a new map, it doesn't mean we need to evaluate it for fairness. So that's where I think I kind of on the same thought that Angelina had, where I kind of want to see there are people being disadvantaged, so there is an actual injury and there is an issue with the way the map is drawn, and it's not just this is a new map, so there's got to be an issue with it. But I do want to make sure that it is being drawn in a way that's unfair if we are to lean that way. So I'm just I think I'm the same road as Angelino. Sorry, I'm just struggling to articulate thoughts today.
Yeah, I'm excited to see petitioner's argument. You guys ready for the blue vote?
Yes.
Alright. So, this is for a oral argument. I will say aye as Justice Turner.
I, Justice Gergen.
Justice LaFleur.
Justice Moore.
Alright, that's it.
That's not fun. Okay, there's one more. Sorry, guys. I feel like I kept just like stumbling over it. You know what?
In validity of Article 3's minimum seat requirements, the doc is titled In Re Nullity of Minimum Seat Requirements, brought by petitioner Tyler Shklar. It appears that petitioners are requesting jurisdiction under 3B1 by asking us to interpret the constitutionality of the minimum seat requirement. I'm not aware of a case that directly discusses the minimum seat requirements, but there are plenty of cases that, as we know, go over a portion of. I also understand petitioners' fear of the voting dilution requirements, but I will say that their requested remedy does appear extreme, as they're requested to be null and void. Maybe we could work out something with them, or maybe not, but I want to hear y'all's thoughts.
Yeah, I think I agree with what you're saying with the apportionment being cases that are similar and whatnot, and I think it's too, when the other legal precedent cited is an election case from the 60s. I think that all those potentially interesting to me, and I don't know, to me, I don't want to say like I want more because it's so broad, but I'm similar to you in the sense that I'm hesitant to just completely have it as null and moot and all those things, just because the minimum seat requirements do ensure that certain colleges get a voice in the Senate, and I think it's important that everyone be represented, and I think that's kind of where this is coming from. So that's where my hesitancy lies, and straight up saying it's unconstitutional, or straight up like taking away this article, or this section.
Yeah, I think that there is so far like jurisdiction standing. The 1960s case that I was also looking at, just because prior cases just had precedent from like more recent case law, so that's why I'm hesitant to just follow suit, because I want to fully grasp their argument, considering that is how a Senate functions, like how our school does it. It's like a very common thing to see in student governments. Legislative bodies. I'm trying to understand the argument better, but I think it's lacking a lot of footing, to be honest. So
Yeah.
I agree.
No, to go off of that, I think it does protect certain voices by having this mandate. I understand it makes them a little different in terms of the playing field, but at the same time, like if you think about our Senate as a whole, like Rhode Island and California have very different populations, but have the same amount of representatives in the Senate. And so I think it kind of ties into that, and so that's where I'm extremely hesitant to just I'm trying to use the language that it uses, and that's why I'm struggling to directly call it like null and void, but at the same time, if it is giving truly like unequal weight and stuff like that, I also think it's important to hear it out.
Any thoughts, Justice Miller?
I'm looking at the prior case that they cited, the Honor Council, because I was kind of struggling with, they're asking us to declare a section of our Constitution unconstitutional under another section of our Constitution, which doesn't seem possible to me, but I'm seeing the In Re Honor Court appears to be declaring a section of our Constitution null and void because of the Student Honor Council no longer being in existence. I don't think Florida Statute 1004.26 has anything to do with this. It's just saying the student body has to be elected. That's true, that happens. I don't think this is violating the higher power of state and federal law, because both state and federal have senates that are apportioned in the exact same way our senate's apportioned, which is not exactly by one person, one vote, that's what the legislature's for, but I don't know, I understand the request, I understand what petitioner's saying here, but I don't really think this is violating federal or state law or our own constitution, part of our own constitution for a reason, and Brittany's case from last year,
Yeah.
talked about the framers' intent and the purpose behind the language in both these sections, section 2A and 2B, which makes sense to me, but why not hear it, I suppose. I mean, I don't know, I was torn about whether there even is jurisdiction, but this fact that they heard the honor council, the student honor court case, makes it, I guess, allowed.
Yeah, that one line is kind of.
Yeah.
Okay. Alright, well, I guess we'll bring it to a vote for a hearing or to dismiss, or oral argument to dismiss. I guess I'll start. I, Justice Turner, for a oral argument.